Hello, YouTube, Twitter, Instagram, the internet, wherever you're reading this from. I've just put a prompt into Gemini AI to do some deep research. It's going to be a long one, so in the interest of time and expediency, let's get into it. So the prompt I put in for my deep research today reads, following the Supreme Court ruling Swindon versus Worcester, it was deemed that funding for NHS treatment will be determined by place of ordinary residence, which includes treatment for mental health disorders, rather than the statutory basis by which the first funder used to be responsible in the case of detentions under Section 2 or 3 of the Mental Health Act. NHS published guidance entitled Who Pays, which openly contradicts the precedent of doctrine set by the Supreme Court. Please research the case law, its implications for integrated care board funding appropriation for detentions under section in the UK, and highlight the potential negative factors for patients who are detained and funded by an NHS trust, potentially hundreds of miles away from a place they may have lived decades before. It's searched many websites and has got a piece of research which I'll begin reading for you just now. Implications of Swindon versus Worcester ruling on NHS funding for mental health detentions in the UK. 1. Executive summary. The UK Supreme Court's judgment in Swindon Borough Council versus Worcester County Council delivered a significant clarification regarding the responsibility of local authorities to fund aftercare services under Section 117 of the Mental Health Act 1983. The court determined that the obligation of the initial local authority ends when the individual is subsequently detained under Section 3 of the Act, and a new duty arises for the local authority in whose area the patient was ordinarily resident immediately before the second detention. The ruling was a response to a period marked by considerable ambiguity and numerous disputes concerning the interpretation of ordinary residence in these specific circumstances. That's from supremecourt.co.uk. However, a potential conflict emerges with the NHS Who Pays guidance, which governs the funding responsibilities of integrated care boards, ICBs. This guidance suggests that the ICB responsible for an individual's care at the time of their initial detention under the Mental Health Act generally retains the funding responsibility for any subsequent detentions and associated aftercare, even if the individual has moved to a different geographical area in the interim. The latest iteration of the Who Pays guidance explicitly states that the Supreme Court's decision does not alter the established rules for the NHS Commissioner's responsibility in these matters. That's from gov.uk. This potential contradiction carries substantial negative implications for patients detained under the Mental Health Act, particularly those whose ordinary residence, as defined by the Supreme Court, is geographically distant from the area of the Integrated Care Board responsible for funding their treatment. Such individuals may encounter significant difficulties in accessing crucial family support, appropriate aftercare services tailored to their current location, and community resources with which they are familiar. That's from kff.org. Legal analyses have indicated that the NHS guidance approach to integrated care board funding might not align with the legal principles established by the Swindon versus Worcester ruling, potentially leading to further legal challenges and inconsistencies in the application of funding responsibilities. The distinction made within the guidance between commissioning and final responsibility appears to be the mechanism through which the NHS maintains this differing stance. That's from debeechcroft.com, whatever that is. This report will provide a detailed examination of the Supreme Court's ruling, analyse the relevant sections of the NHS Who Pays guidance, highlight the areas of contradiction, explore the ramifications for ICB funding, detail the potential adverse consequences for patients, and review the existing legal and policy critiques. The concluding section will offer recommendations aimed at addressing these discrepancies to foster a more consistent and patient-focused approach to the funding of mental health detentions. Introduction. Section 117 of the Mental Health Act 1983 imposes a shared responsibility on integrated care boards, ICBs, and local authorities to provide or arrange for the provision of aftercare services for individuals discharged from detention under specific sections of the Act, including Section 3. That's what I'm on. The primary objective of this duty is to address the needs arising from a person's mental disorder and to mitigate the risk of their readmission to hospital. That's from Section 117 from that DAC Beechcroft site again. The case of Swindon Borough Council versus Worcester County Council was brought before the UK Supreme Court to resolve a dispute between two local authorities concerning the financial responsibility for aftercare. So this isn't treatment, it's aftercare services for an individual, JG. JG had been detained under Section 3 of the Mental Health Act on two separate occasions, residing within the jurisdiction of a different local authorities, of the jurisdiction of different local authorities between these periods of detention. This case emerged from a context of considerable uncertainty and numerous disagreements regarding the interpretation of ordinary residence. In the specific context of Section 117, Supreme Court's intervention was highly anticipated to provide a definitive legal interpretation on which local authorities should bear the responsibility for funding aftercare in such situations, aiming to bring to end a period of limbo for similar disputes across the country. That's Supreme Court. NHS Who Pays guidance document published by NHS England serves as the authoritative framework for determining which NHS commissioner, now primarily integrated care boards, is responsible for both commissioning and paying for an individual's healthcare within the National Health Service. This guidance is fundamental for establishing financial accountability within the NHS system, encompassing mental health services and the care provided to individuals detained under the Mental Health Act. The most recent version of this guidance, effective from the 1st of April 2024, incorporates amendments resulting from the Health and Care Act 2022 and its associated regulations. That's from an NHS England website. The central issue this report seeks to address is the potential contradiction that has arisen between the legal precedent set by the Swindon Borough Council versus Worcestershire County Council Supreme Court ruling concerning the responsibilities of local authorities, which hinges on the concept of ordinary residence immediately before each detention, and the NHS Who Pays guidance. The latter appears to maintain a different approach for our integrated care board funding, potentially based on the principle of the originating integrated care board. This discrepancy raises significant concerns regarding legal compliance and the potential for inconsistencies in how the treatment for mental health detentions is funded, which could ultimately impact the well-being of patients who might be detained far from any location they could reasonably consider their ordinary residence based on their recent history. From gov.uk. The Swindon versus Worcester Supreme Court ruling, analysis of key findings. The case of Swindon Borough Council versus Worcestershire County Council revolved around JG, who was initially detained under Section 3 of the Mental Health Act in Worcester in March 2014. Upon her discharge in July 2014, a decision was made in her best interest for her to reside closer to her daughter in Swindon. Consequently, she was placed in a care home within Swindon, with the costs of her aftercare services being covered by Worcester County Council. In June 2015, JG experienced a deterioration in her mental health, leading to her second detention under Section 3, this time in a hospital located in Swindon. Following her second discharge in August 2017, a dispute arose between the Worcester and Swindon Borough Councils regarding which authority held responsibility for funding her ongoing aftercare. mentalhealthlaw.co.uk. The Supreme Court's key findings offer significant clarification on the interpretation of Section 117. So that's taking care of the patient when they leave the hospital, Section 117, not who's funding it while they're in hospital. They're two separate things. Just to clear up any disambiguation there. Definition and application of ordinary residence. The court firmly stated that the term ordinary resident, as used in Section 117 of the Mental Health Act, should be interpreted according to its established common law meaning, as articulated in the landmark case of R versus Barnet, London Borough Council, ex part Shah 2 AC 309, whatever the fuck that means. This definition refers to an individual's settled abode in a particular place, adopted voluntarily and for a settled purpose as part of the regular pattern of their life. The court explicitly rejected the argument that the act of providing accommodation within other local authorities' area, even when the costs are borne by the original authority, inherently prevents the individual from acquiring ordinary residence in the new area. Furthermore, the Supreme Court drew a distinction between the present case and its previous ruling, R. Cornwall Council versus Secretary of State for Health, UKSC 46, clarifying that the principle established in Cornwall concerning the deeming of ordinary residence within specific statutory contexts should not be extended to a Section 117 of the Mental Health Act, which lacks a similar deeming provision. In the specific circumstances of JG's case, the court concluded that she had indeed established ordinary residence in Swindon immediately before her second detention. This determination was based on the fact that her residence in Swindon was the result of a best interest decision made on her behalf and was adopted for settled purposes. This emphasis on a factual assessment of ordinary residence immediately preceding the relevant detention provides a clear guiding principle for both authorities in similar situations. The court's refusal to extend the Cornwall principle to Section 117 underscores that, in most cases under the Mental Health Act, ordinary residence should be determined by applying the common law test. That's from Beechcroft again. Cessation of Section 117 duty upon re-detention. The Supreme Court also delivered a crucial ruling on the point at which the duty to provide aftercare under Section 117 comes to an end. The court held that this duty automatically ceases if and when the individual concerned is detained once more under Section 3 of the Mental Health Act or any other provision specified in Section 117. The rationale behind this decision is that during a period of detention within a hospital for treatment, the individual no longer meets the criteria of a person who has ceased to be detained and has left hospital, which are the prerequisites for Section 117 duty to apply. Upon a subsequent discharge from this second or any further detention, a new duty to provide aftercare services arises. The local authority responsible for this new duty is determined by the location where the individual was ordinarily resident, immediately before the second detention. The court clarified that this automatic cessation of duty applies specifically to detentions under Section 3 and does not necessarily extend to informal admissions or detentions under Section 2 for assessment purposes. This finding establishes a clear endpoint for local authorities' Section 117 duty in cases involving re-detention under Section 3, thereby preventing the potential for concurrent or conflicting duties between the different local authorities. It also overturned the decision of the Court's appeal, which had previously held that the initial duty continued until a formal decision was made that the person no longer required aftercare. mentalhealthlaw.co.uk. The Supreme Court's judgment carries significant implications for how local authorities ascertain their responsibilities for commissioning and funding aftercare services under Section 117 of the Mental Health Act, particularly in situations involving individuals who move between different local authority areas and experience multiple episodes of detention. 4. NHS Who Pays Guidance, Review of Funding Responsibilities for Mental Health Detention. The most current publicly accessible version of the NHS Who Pays Guidance is dated March 2024 and took effect on the 1st of April 2024. This version supersedes the previous guidance issued in June 2022. The Who Pays Guidance lays out the framework for determining which NHS Commissioner, primarily integrated care boards, is responsible for both arranging, commissioning and paying for an individual's healthcare within the National Health Service. That will be a link to that NHS England document. Within the guidance, there are specific sections dedicated to addressing the funding responsibilities for individuals detained under the Mental Health Act 1983. These sections delineate the rules for establishing which ICB holds the core responsibility for commissioning and covering the costs of services, including hospital detention and subsequent Section 117 aftercare. A central tenet within the Who Pays Guidance, particularly relevant to individuals detained under the Mental Health Act, is that the ICB, which holds core responsibility for the patient at the time of their first detention, under a relevant section of the Act, such as Section 3, generally retains the responsibility for commissioning and paying for both the detention itself and any subsequent Section 117 aftercare. This responsibility continues until the patient is formally discharged from aftercare services or passes away. This is commonly referred to as the originating ICB principle. This responsibility remains even if the patient moves to a different geographical area within the country and is subsequently re-detained. Significantly, the updated Who Pays Guidance explicitly addresses the Swindon versus Worcester Supreme Court judgment. It clarifies at the beginning of paragraph 18 that the judgment does not affect the operation of the rules relating to establishing the responsible NHS Commissioner for detention and aftercare. So that's both the detention and the aftercare, two separate funding appropriation sources under the Mental Health Act 1983. The guidance instructs ICBs to continue to apply the rules outlined in paragraph 18, for determining responsibility for detention and aftercare, which are firmly based on the originating ICB principle. This indicates clear divergence in approach between the Supreme Court's ruling on local authority responsibility, which resets with each Section 3 detention based on ordinary residence, and the NHS guidance for Integrated Care Board responsibility, which remains with the ICB responsible for the initial detention, regardless of subsequent detentions or changes in ordinary residence. More of that document. 5. Contradictions and misalignments. Comparing the Supreme Court ruling and NHS guidance. The fundamental contradiction arises from the differing criteria used to determine funding responsibility for subsequent mental health detentions under Section 3. The Swindon v Worcester ruling explicitly states that for local authorities, a new Section 117 duty is triggered based on the individual's ordinary residence immediately before each detention under Section 3. This implies that if a patient relocates to a new local authority area and is subsequently detained again, the financial responsibility for aftercare following that latter detention would shift to the new local authority, provided they were ordinarily resident there immediately before the detention. Gets a bit confusing there. Conversely, the NHS Who Pays guidance for ICBs maintains that the ICB responsible at the time of the individual's first detention under the Mental Health Act generally remains responsible for funding any subsequent detentions and aftercare, even if the individual has since moved to a different ICB area. The guidance explicitly states that the Swindon v Worcester ruling does not alter this established principle for integrated care boards. This creates a significant misalignment where the local authority deemed responsible for aftercare funding based on the Supreme Court precedent might be different from the ICB responsible for funding according to the NHS guidance. For instance, in the scenario described in the user query, if a patient has resided in Qstoke for many years but is detained under Section 3 while visiting Swindon, the Supreme Court ruling suggests Swindon Council would be responsible for aftercare funding upon discharge. However, if the originating integrated care board was in Qstoke, based on a previous detention years prior, the NHS guidance indicates that Qstoke integrated care board would remain financially responsible. So, wherever you were first sectioned, they'll always be responsible for providing your care, which is wrong since the Supreme Court ruling. They shouldn't be doing that anymore, and they are, basically. This misalignment has the potential to generate considerable confusion and could lead to disputes between local authorities and integrated care boards regarding the allocation of funding and responsibilities for individuals with complex mental health needs who experience multiple detentions across different geographical regions. Despite the Supreme Court's aim to provide clarity and reduce disputes among local authorities, the differing stance in the NHS guidance could simply shift the focus of all these disputes to involve integrated care boards as well. 6. The impact on integrated care boards funding allocation. The NHS Who Pays guidance clearly articulates that the Swindon v Worcester ruling does not impact the established rules for determining the responsible NHS Commissioner ICB for detention and aftercare under the Mental Health Act 1983. Consequently, integrated care boards are expected to continue to adhere to the originating ICB, that's first funder principle, where the ICB responsible at the time of the individual's initial relevant detention generally retains the funding responsibility throughout subsequent detentions and aftercare periods. This position is further underpinned by the National Health Service Integrated Care Board Responsibilities Regulations 2022, which outline the core duties and responsibilities of integrated care boards. These regulations appear to prioritise the continuity of integrated care board responsibility based on the initial connection with the patient, potentially for the entire duration of their aftercare needs, irrespective of where they might reside or be detained in future. The approach can have significant financial implications for ICBs. If an individual is initially detained within the geographical area of one integrated care board, but subsequently moves and lives for an extended period within the area of a different integrated care board, any subsequent detentions under Section 3 would, according to Swindon v Worcester ruling, likely render the local authority in the new area responsible for aftercare funding. However, the originating ICB would still be responsible for funding the NHS component of that aftercare. This could result in an ICB being financially responsible for a patient who now resides hundreds of miles away, potentially for many years, and whose local support networks and aftercare needs are primary within the geographical area of the new ICB. So I used to live in Devon and now I live in Bristol, but I'm still getting Devon Partnership Trust funding my healthcare and treatment and my beds, even though I've lived in Bristol for 4 years. That's what's happening to me. This situation could impose a financial burden on the originating ICB to commission and manage a managed service in a distant location, potentially leading to inefficiencies and challenges in ensuring the patient receives the most appropriate and locally responsive care, as mentioned in my prompt. It also raises questions regarding the equitable distribution of funding across different ICBs if one ICB bears the long-term financial responsibility for individuals who've permanently relocated to another area, a bit like moving from Devon to Bristol. 7. Negative consequences for patients detained far from ordinary residents. The divergence between the Supreme Court ruling and NHS guidance regarding funding responsibilities can lead to several adverse consequences for patients detained under the Mental Health Act, particularly when their ordinary residence, as defined by the Supreme Court, is far more removed from the area of ICB responsible for funding their care. Access to family support. When funding is linked to an integrated care board in a distant location, it can severely restrict a patient's access to family support. Family members may face substantial travel costs and significant time commitments to visit a patient detained hundreds of miles away. This geographical separation can exacerbate feelings of isolation, anxiety, and distress for the patient, potentially hindering their recovery. The infrequency of family contact can also limit the family's ability to actively participate in care planning and provide essential emotional and practical support. Maintaining strong family connections is crucial for the mental well-being of individuals in detention, and funding models that necessitate detention or treatment far from these vital networks can be profoundly detrimental to their mental health and recovery prospects. Potential impacts of mass detention and deportation from kff.org. Aftercare services. Planning and accessing appropriate aftercare services within the area where the patient is currently living can become significantly more complex if the funding responsibility rests with an ICB in a distant location. Much to my query. The ICB responsible for funding might possess limited knowledge of the local resources and support networks available in the patient's current area of residence. As in, Devon don't know much about Bristol. I'm being funded by Devon, but I live in Bristol. This can lead to delays in arranging suitable aftercare or the provision of services that are not well integrated with the patient's local community. Furthermore, the local authority, which according to the Supreme Court ruling might bear the responsibility for the local authority components of aftercare, could encounter difficulties in coordinating with an ICB that's geographically remote and operating under a different funding principle. Effective aftercare necessitates a thorough understanding of the patient's immediate environment and access to community-based support. Funding models that decouple funding from the patient's current residence can create substantial obstacles to accessing timely and relevant aftercare services. Familiarity with local resources. Patients detained far from their ordinary residence are likely to be unfamiliar with the specific mental health services, support groups, and other community resources available in the area dictated by the originating ICB. I haven't been to Devon for years, not since, well, I went there camping in 2024, but previously hadn't been there since 2019. By the originating ICB funding model. For me, that's Devon Partnership, NHS Devon Partnership Trust, not Avon and Wiltshire Partnership Trust, who I should be getting funded by. This lack of familiarity can present a major impediment to their successful reintegration into the community upon discharge. Even if aftercare services are arranged, the patient might not feel connected or comfortable accessing resources in an unfamiliar area, particularly if they've resided in their current location for a considerable period. Re-establishing a sense of belonging and accessing local support networks are integral aspects of recovery following mental health detention. Funding models that prioritise a distant originating integrated care board can undermine this crucial process by directing patients towards resources in areas with which they have no connection or familiarity. Table, potential negative factors, the patients detained far from their ordinary residence. So you've got reduced family support. Description, geographical distance due to due to funding linked to a distant ICB limits visits, emotional support and family involvement in care planning. Impact on the patient is increased isolation, anxiety, distress and potential hindrance to recovery due to lack of crucial social support. Disrupted aftercare planning. Planning and access to aftercare services in the patient's current location may be complicated by funding tied to a distant originating integrated care board, unfamiliar with the local resources. Delays in arranging appropriate aftercare. Provision of services not tailored to the patient's current location needs and potential lack of coordination between the funding ICB and the local services. Lack of local familiarity. Patients Patient and their local support network are unfamiliar with mental health services, support groups and other community resources in the area of the distant originating ICB. Difficulty and the impact on the patient is the difficulty reintegrating into the community upon discharge, reduced engagement with unfamiliar resources, increased risk of social isolation and potentially higher risk of relapse and readmission. Let's go back to the negative factor of cultural and social isolation. The distant originating integrated care board area might have different cultural norms, social networks and community support systems that are unfamiliar to the patient, especially if they've lived elsewhere for decades. Increased feelings of alienation and displacement, difficulty building new support networks in an unfamiliar area, exacerbation of existing mental health issues and potential for social exclusion. Logistical challenges, travel for appointments, communication with service users in a distant area, and other logistical hurdles can be burdensome and stressful for the patient and their local support network. So this could lead to increased practical difficulties in accessing and engaging with necessary services, potential for disengagement from care due to logistical barriers, and added stress on the patient and their local support system. 8. Legal policy and analysis, criticisms of the Who Pays guidance. This is the main bit that this video is about. Legal commentators who have expressed concerns regarding the NHS Who Pays guidance stance on ICB funding responsibilities for mental health detentions in light of the Swindon versus Worcester Supreme Court ruling. A central point of criticism is the potential conflict between the Supreme Court's emphasis on ordinary residents immediately before each detention for local authority responsibility and Who Pays guidance continued reliance on the original ICB, that's first funder principle. This can lead to funding being tied to an area where the patient no longer has any significant connection. This discrepancy has been highlighted as potentially undermining the clarity that the Supreme Court aimed to achieve with its ruling. Some legal analyses suggest that the continued adherence to the originating ICB principle for funding, while the local authority responsibility shifts based on current or ordinary residents, could lead to further legal challenges and disputes between ICBs and local authorities. That's from that Beechcroft website again. The Who Pays guidance attempts to address this potential conflict by drawing a distinction between the commissioning of services and the financial responsibility for Section 117 aftercare. So that's your health being funded by one person and your aftercare, which is making sure you've got somewhere to live and a package of medicine and care, support in the community. It's two different things. So responsibility for Section 117 aftercare. While the arrangement of services might occur in the area where the patient is currently residing and receiving treatment, the financial burden, according to the guidance, can still rest with the originating ICB. This distinction appears to be a mechanism by which the NHS seeks to maintain its established funding model for the ICBs, despite the Supreme Court's ruling on the local authority responsibilities. However, this approach has been criticised for potentially creating a system where the ICB with financial responsibility is geographically distant from the patient and the local services, potentially hindering effective care coordination and responsiveness to the patient's immediate needs. That's from bevanbritain.com. Furthermore, the continued application of the originating ICB principle raises questions about local accountability and responsiveness in the provision of mental health services. If an integrated care board is financially responsible for a patient residing within another integrated care board's area, there might be a reduced incentive for the originating ICB to be fully engaged with the patient's current needs and the local service landscapes in their area of residence. This could result in a fragmented system where the ICB holding the financial responsibility is not best positioned to understand and meet the patient's evolving needs within their current community. 9. Conclusions and recommendations. The Swindon versus Worcester Supreme Court ruling has provided essential clarification on the interpretation of ordinary residents and the termination of Sections 117 duty for local authorities in cases involving subsequent mental health and detentions under Section 3. The ruling emphasises a factual assessment of ordinary residents immediately preceding each detention and the automatic cessation of the previous duty upon redetention. However, the NHS Who Pays guidance maintains a different approach for integrated care boards, continuing to apply the originating ICB principle, where the ICB responsible for funding at the time of the initial relevant detention generally retains this responsibility for subsequent detentions and aftercare, irrespective of changes in the patient's ordinary residence. This position is explicitly stated in the latest version of the guidance, which asserts that the Swindon versus Worcester ruling does not affect these established rules for NHS commissioners. This discrepancy presents potential challenges for patients detained far from their ordinary residence as defined by the Supreme Court. Funding determined by a distant originating ICB first funder from where you lived years ago that you don't live anymore can impede access to local family support, aftercare services and familiar community resources, potentially impacting their recovery and well-being. To address these issues and foster a more coherent and patient-centred system, the following recommendations are proposed. A review and alignment of who pays guidance. NHS should undertake a review of the who pays guidance in light of the Swindon versus Worcester ruling. While the legal framework governing integrated care board responsibilities may differ from that of local authorities, exploring a greater alignment in underlying principles, particularly regarding the significance of a patient's current ordinary residence, should be considered to ensure a more responsive and locally focused approach to care. Enhanced collaboration and communication. Clear protocols should be established to facilitate effective communication and collaboration between the originating ICB and the ICB and local authority in the area where the patient is currently residing and receiving treatment. This would help ensure that local needs are understood and addressed even when funding responsibilities are divided. Patient-centred approach. The well-being of the patient should remain the paramount consideration. Funding arrangements should prioritise access to services and support networks in the patient's current area of residence, minimising disruption and maximising the effectiveness of aftercare. This might involve exploring mechanisms for transferring funding responsibilities to the ICB in the area of the patient's current ordinary residence after a defined period or under specific circumstances. Sorry, I've got a bit of a dry mouth today. Clarification of legal framework. A comprehensive legal review of the interaction between Section 117 of the Mental Health Act, the ICB responsibilities regulations and the Swindon versus Worcester ruling should be conducted to clarify the legal obligations of both local authorities and integrated care boards in funding mental health detentions and aftercare. This could lead to legislative or regulatory amendments aimed at ensuring a more consistent and equitable system. Strengthening dispute resolution mechanisms. Existing dispute resolution mechanisms between ICBs and local authorities should be reviewed and enhanced to effectively address disagreements arising from the differing interpretations of funding responsibilities in light of the Swindon versus Worcester ruling and the who pays guidance. By addressing these discrepancies and prioritising a patient-centred approach, the NHS can work towards a more equitable and effective system for funding mental health detentions, ensuring that individuals receive the care and support they need in a manner that promotes their recovery and well-being, irrespective of historical funding arrangements or geographical boundaries. There's all the websites it looked at. I'll post a link to this in the description. And effectively, what I'm getting at is that this first funder system has been abolished by the Supreme Court in the United Kingdom. You can't get around that. There's no way around it. You can't, doesn't matter if you're a private sector organisation or if you're a public sector organisation that's worth 500 billion and employs over 1 million people, the biggest employer in Europe, in fact, per capita, you still can't Supreme Court abdicate and kind of usurp and just fuck it off because you feel like it and you want to cover up for, you know, a whole load of bad things that don't suit your narrative as an NHS trust. This is a 33-minute video. Please read the description of the research and understand its purport and its logical value. And I hope that anybody else who's having the same problem is able to access the resources and support and guidance. And if anybody wants to help me on my journey, to tell the NHS that they're wrong, that as Gemini has quite clearly put out, they should rethink their shit and get their act together and stop using funding services for where people have lived literally decades before, that are hundreds of miles away, where you can be shipped off to a hospital in a place where you don't live, for no fucking reason. Anyway, that's that. Thanks for your time and your energy and your 33 minutes and 54 seconds of your life.